Good day, colleagues. Today we're looking at the last in a series of presentations on solving your client's problems. And today we're looking at the importance of assessment and self-assessment. So let's get into it. In this video, we're looking at the objectives of assessment in the law of remedies, what summative assessment is about, and how it is dealt with in this course. We're looking at the marking criteria on which you are going to be assessed. We are looking at assessment as an even greater need for self-assessment, and we're looking at professional standards. So let's go into the objectives of the assessment. The objectives of the assessment are the same as the final exam. To achieve the course objectives, which are to test whether you have developed 1. The characteristics, discipline, and skills of an effective attorney at law. If you don't have the attitude and values of the attorney, which is to serve your client, to provide a cost-efficient solution to his problems, to meet him at his needs, and to be relevant to the solution. In other words, if the client is poor, but you have opted for the most expensive solution, then you're not serving your client. And so it is the characteristics, discipline, skills are all important. Your attitude and your values and how you see yourself as an attorney is absolutely critical to the kind of solution that you bring to bear on the client's problems. The ability to advise on appropriate litigious and non-litigious remedies available to your client to solve this problem. Again, the client wants to solve this problem. He does not care whether it goes to court, whether it goes into negotiation, ADR, or whether it's a social political action, but he needs to know, and the best service you can provide for him, especially in the modern days where litigation is so expensive and where there are other non-litigious methods of resolving disputes, you need to be much broader in your range of tools and the arsenal that you bring to bear on solving his problems so that he can get the best possible solution. In that way, you keep a client, and you keep a client for life. The ability to assess and quantify the measure of damages arising out of breaches of contract and tort. Well, this is a core element of the course, which traditionally has been what has been tested, and it is still so today. The ability to prepare and present arguments and opinions on the assessment of damages in litigious proceedings. Again, the whole ethos and methodology of the course speaks to this issue. How you write, how you present arguments, how you use different, whether it's an advice on quantum, whether you're using an argumentative method, whether you're using the IRAC method. What is the most appropriate tool in order for you to analyze the facts and the law and solve your client's problems? How is it that you best present arguments? And so even your presentations in class are methods of developing the skills that you need for presentation. And these are all parts of the assessment. So, and you will notice, for instance, that in the assessment criteria on presentation, you will see all of these things reflective of your language, your structure, your use of logic and the chronology and the seamless way of moving from one point to the next. All of these are elements of presentation, and all of these speak to the ability to present effectively in court. Okay, so what is summative assessment? Summative assessment means the type of assessment that is used to determine whether you get a grade and the extent and the measure of the grade that you will get to assess your skill that will impact on your advancement in the law school. So that as opposed to assessments which are formative, which are designed to help you and assist you to improve those skills, but don't have an impact on your final grade or the final measure by which your success at the law school will be achieved. It is no secret that I do not believe that the final all stakes, high stakes examination in the law of remedies is the most appropriate method of assessment. And I have, or at the law school, and I've spoken about this and I've critiqued uh, the very restricted methods of assessment that we have. And if you want to take a look at my comments, you can look at it at this blog post that you have in front of you. Now, the exam itself is divided into two parts. The first part consists of one compulsory question on drafting and advice on quantum. And that is because an advice on quantum is the fundamentals upon which you develop any litigation strategy, on which you quantify your loss, the compensation for your client, and which can also help you in developing negotiations to solve your client's problems. You have then a choice of two other questions which are equally weighted. You have one out of them. You can either do a question on damages for personal injuries or damages arising from wrongful death. Those two areas are equally weighted, and they are two very fundamental, critical parts of the assessment of practitioners. The reason why I have given you a choice is because both are very heavy and, excuse me, but they are very long and time consuming and very involved. And so I try to ensure that students don't make the wrong decision by trying to do both of them, as has been done in the past. Now, part two of the paper leaves you with two questions out of three. And the first one of the questions will be a multi-part question on any subject in the course which has not been tested up to that point. A multi-part question is a question which has 3 or 4 different parts. Each part has a specific objective, and you have to be able to answer the question in relation to the question or the issues that you are asked to address in that part. If you do not answer the question, or if you answer the question in another part of the answer, then you have not really answered that part. You're not going to be credited for it. The purpose for this is to be able to help you to understand that in one subject area, there are critical elements that need to be addressed, and the questions are designed to address those areas. It is, in a sense, helping you to answer the question fully and by directing you to specific areas. When you do not read the question and what is asked, and you do not answer what you are asked to do, one, you demonstrate that you cannot follow instructions, which is a critical uh, requirement of an attorney, and it has ethical implications. Two, that you simply may not know the answer. Okay, so that's the multi-part question. Then there's a question on alternative remedies, which may be a full essay type problem answer, or it may be a multi-part question, which again, it could be either way, okay? But there will be a question that is devoted entirely to alternative remedies. And then you have a multiple choice question, which is designed to take up the slack of anything that you may not have done in the course elsewhere. In other words, if you did a topic in, let's say, damage to land in the first, in the advice on quantum, whatever it might be, and then you did a question on personal injuries, you would not have done one on wrongful death, but wrongful death will come here. So you'll have a question on both personal injuries and wrongful death inside of the multiple choice question. And so you will have to, you cannot get away from answering all the topics in the course. The reason for that is that remedies is not a very wide course, and it covers, as I keep telling you, 75% of the knowledge that you are required to learn in remedies you came to the law school with. So we need to test that knowledge to ensure that you can provide the best service to your clients. And so the multiple choice question is helps to, one, show that you can discern and rationalize the work that you have done. it is designed specifically to test your critical thinking and problem solving skills. I would say to you now that my examiners who saw the multiple choice questions uh, in the mock exam last year thought that it was onerous, but when they saw it in the exams and they saw students responding to it, they realized that it was a much better test of students' critical thinking and problem solving abilities than even the problem essays. And so this is just more reinforcement that that you need to pay attention to this, especially if you want to do this question in the exam. As a matter of fact, all my questions are designed for critical thinking and problem solving so that as we go through the year, you will be getting multiple choice questions on the blog. My suggestion to you is that they are quick, they are short, uh, and they are designed to test how much you know and how well you understand. And it is in your own interest to do them as much as possible and to see exactly where you are deficient and to beef up on those areas as you go through the year so that you don't get surprises in the examination results. Okay, so how are the marks distributed? How is the course tested? There's a numerical marking scheme that I use. Well, first of all, the law school uses a literal scheme, which means that you get an A, B, C, or D. But to get that, I use a numerical scheme to ensure that that we understand exactly what we mean and what values we put to those literal grades. And I use a scheme where I mark papers out of 20, and an A goes from 18 to 20, B 15 to 17, C 12 to 14, D 0 to 11. Uh, this is my marking scheme. This is what my standards are. My standards for remedies is that if you have to be competent in remedies, which is the critical reason why clients come to lawyers, is that you have to be better than borderline. Okay? I will say this to you. If you will, because when you leave the law school and clients come to you, there's no other time to practice, there's no other time to develop yourself. Your response to those clients are the effect of a surgeon who goes to school, comes out and has to do surgery on a patient. And if his pass mark at surgery school was 50%, then what the school is certifying is that he is as likely to kill somebody as to save them. That is not, especially in a skills-based course where what you do it affects people's livelihood, their life in case of the surgeon, their life or death decisions. In the case of the lawyer, the person's livelihood, their liberty, and so on. Your decisions in how you apply yourself to your practice has that effect. And so to be competent, you have to be much better than simply borderline. And so a C starts from 12 because they are critical areas of competency that you have to be competent in all of them. And so that's why you have C that starts effectively at 60% for me. Okay? So you are being tested on, okay, sorry, let me just get rid of this. Right. There are four major criteria for success. The first is knowledge of substantive law. And that means that where applicable and appropriate, students should be able to identify and articulate, make notes of the word, where applicable and appropriate. So the substantive law has to be applicable and it has to be appropriate. So if you are telling me, for instance, that the test for remoteness in tort is the direct loss, that all losses that directly flow from the uh, from the loss is recoverable. And in the second instance, where special knowledge exists at the time of the contract, that in the minds of both parties, then those losses are recoverable. You are applying a contract test to a tort situation. Or as very often students do, they will tell me you have to be, the object of the award is to, sorry, the test of remoteness is reasonable recovery, or sorry, reasonable foreseeability. And sometimes that is all they tell me, okay? And then they will cite Hadley and Baxendale. Well, if you are saying part of a test in tort but citing a case in contract, you're telling me that you don't know what the law is, okay? Secondly, if you, so that is not applicable nor appropriate, then students should be able to identify and articulate. So while you were able to identify the test of remoteness as in tort as reasonable foreseeability, that is not an articulation of the test. An articulation of the test is the full test, because you can't apply, for you to apply the test, which is the second criteria, application of the law, I must be able to know exactly what all the elements of the principle are, all the relevant principles, all the relevant elements of the principle are, to know whether the test applies or is applicable to the facts. So a full articulation of the test is that for a matter to be, for an item of loss to be recoverable, the nature of the loss must be reasonably foreseeable at the time of the loss. And once that loss is foreseeable, the manner in which or the extent to which a loss has occurred is immaterial. Now I can take a particular item and apply the test to it and see whether it applies or not. So you have to be able to identify and articulate the range of possible causes of action arising from the facts. Because if you don't know that an item, a loss arises from contract or tort, then you can't determine the appropriate test, especially for the objective of the award or for the test of remoteness. You must be able to identify the relevant types of remedies available on the facts, and you should be able to state the applicable principles to be applied to the assessment of damages, where the test revolves around, the question revolves around the assessment of damages. Now, this second one deals with alternative remedies. Okay, so with alternative remedies, you need to be able to identify and articulate the relevant types of remedies available on the facts. And when it comes to the assessment of damages, you should be able to identify the applicable principles to be applied to the assessment of damages, meaning all of those preliminary areas plus the specific principles that may apply to the particular head of loss. Now, the next criteria is application of law to facts. What does that mean? Where applicable, students should be able to apply relevant principles of law to the problem. So there has to be a discussion between the law and the facts. You cannot simply state the law and say, well, because I've stated the law, this is the result. There has to be a discussion as to, for instance, if we are applying the issue of the principle of remoteness and the nature of the loss. If you were to look into the Quarry case that we had, and inside of that car, there were several different types of items. There were computers, there was food, there was clothes and valuables. Then the person looking objectively at the time of the loss would be asking himself, and of course the person is injured, what can I anticipate will be lost in this vehicle? On a remote second grade road in a remote area where it's difficult for ambulances to get to in a timely fashion. And so I will, and the severity of the impact of the crash, I would expect that several items will be damaged or destroyed. I expect that persons will be severely injured. I expect that they will go to the hospital. I expect that uh, certain things, if you had food, bottles will break, liquid will spill out onto clothes, all of those things, all of these, there are a whole range of things that I can foresee will be damaged or destroyed that are in the car. And so what is the nature of the loss? The nature of the loss really is anything that you can foresee a reasonable person putting in his car. And as far as I am concerned, as a reasonable driver, as a regular driver on the road, I put every and anything in my car that my car can take. Uh, I probably would not put sticks of dynamite um, or explosives in it, but apart from things that are going to do me harm in the event that uh, other than that, I think that it is reasonably foreseeable that I can put almost anything in my vehicle. And so all of the things that are put there, so this is the reasoning process, okay? And you need to summarize that in order to make the link between the law and the facts, so that the reasonable man will anticipate that anything that is capable of being carried in the normal course of events, people's personal effects, will be inside there. So when we look at the actual items that have been damaged or destroyed, they fall within that category, and therefore they were reasonably foreseeable. And the manner in which they were destroyed, whether the computer flew through the window and hit a tree, or whether someone came and stole it later on, it still results in the same thing, that it results in a loss to the to the claimant, and is recoverable. Now, many of these arguments can be argued on the other side. So the question is not whether there's a right way or wrong way of arguing. The question is your argument reasonable? And the reasonableness of your argument depends on how you can link the principle to the facts. And if you simply jump from principle and say, well, it is reasonably foreseeable that, no, it's not reasonably foreseeable to me because you have not made out the argument. Okay? So I hope that you can understand that. That is where many students fail, because they are not able to apply the law to the facts. They do not engage in a discussion on the facts and what the facts mean in relation to the law. Okay? So that is something that you really have to do over and over, do many exercises, and ask yourself, how do I articulate this clearly? How do I see these linkages so that you can best understand how this particular element applies to you? Now, problem solving. To just I may have missed out something. Okay, yes. Where the facts are ambiguous, to make assumptions about those facts on which they intend to proceed, or to explore both options. In the final analysis, students must give advice based on the facts. Okay, so sometimes the facts may be deliberately ambiguous because I am trying to test and see whether, one, you understand that the law can go, that there are several different ways that this situation can develop. When that arises, no sweat. State at least two of the ambiguities in the problem on the facts, and say, because it's ambiguous, I am going to choose this particular interpretation of the facts. And you go ahead with that and you leave the other things out. You can choose the easiest one that you believe is the easiest one for you to address. That is no problem for me. What I am testing is whether you realize that there's an ambiguity involved, and that this river that is going down the road has now reached certain obstacles, and it can go in several different directions. Okay? So again, that is an element of approach that is tested. Such advice must relate to the actual facts provided and from those which can be reasonably inferred. Now, reasonably inferred means that uh, when contrary to the approach that you've been taught at the faculty, where you are told to deal only with the facts that you are given, because we are training you in a legal practice environment, very often the clients don't give you all the facts. And you have to use your own common sense and your own knowledge of the law and your experience to be more investigative and to say, for instance, to the client, well, you have not told me the car was damaged, but you've not told me how much it cost to tow the car from Valencia to Port of Spain. You have not told me whether you took how much days off you took to go looking around for spare parts to repair the vehicle. Uh, Almost invariably with basic laws, there is a whole range of consequential losses which arise from that basic laws. And very often students uh, don't only focus on the basic laws that is set in the question, and they don't understand, they don't apply the mind of the practitioner to say, well, okay, we are not told about these other things, but these are factors that will naturally arise from from the laws that we are not told about, and I will need to ask the questions to the client about these things in order to give him the fullest possible advice. So that if it is, for instance, that a house was damaged or a roof was badly put on and the roof was leaking, well, we have to talk about the cost of relocation. Apart from the rental of a place, we have to talk about the cost of relocation, security for the property while the relocation was taking place, rental of a storage unit to store the items in the house, and a whole range of if if the hotel that they stayed in was different from the school district in which the people were living, what additional costs would it be incurred in getting the children to school, getting to work, and so on. All of those things are consequential losses which are directly impacted by the repair of the basic laws. And so while, especially in an examination context, you're not required to be exhaustive, you have to be able to demonstrate that you know that there's an inquiry that you will have to engage in, and that these are other types of losses which, once they are incurred, you have to address them, some of them, to show that you know. Okay, so advice must relate to the actual facts and from those which can be reasonably inferred. Now, when advice of quantum is required, students must be able to quantify the amount the client is expected to receive or should be able to advise the client as to what other information is required so as to be able to do so. This follows on this last part we talked about information reasonably inferred. First of all, students must be able to quantify the amount. One of the biggest differences between an advice on quantum and the IRAC method is that there's a special area in the advice on quantum called quantification, where you, as far as possible, take all the principles that you have applied in your discussions to date to make a dollars and cents assessment of what the client stands to get. And this is what the whole purpose of the advice on quantum is. Quantum, how much? Okay, that is what the client at the end of the day is most interested in. So that you have to be, if you miss that out, then you missed out a substantial part of the advice on quantum, and it will be reflected in your grade. So that is important. Also, because it is designed to give you as the best possible, or give the client the best possible advice on the amount that they are liable, they can possible compensation they can get. Then, when there are deficiencies in the information, you have an obligation to tell the client or to tell your instructing attorney, these are the items of information that are missing that I need in order to make this quantum as comprehensive as possible. Students do not do that. And that is a fundamental area that you lose plenty points on when you leave it out. Okay, so the quantification and because you're so accustomed to law, and you spend a lot of time on that, but the practical elements that relate to your legal practice in terms of one, advice to a client and on how much money, quantum compensation, that is left out. A big no-no. And also, as importantly, what else do I need to make this quantification complete? There is missing information, there's missing evidence, there's missing issues that have to be addressed. You need to get them. Okay, and if you don't put those things in, certainly your marks are going to be depleted because of it. Now, problem solving, alternative remedies. When we're dealing with alternative remedies, students should be able to review the range of feasible solutions, both litigious and non-litigious, that are available. They should be able to decide on and apply the best solution to the client's circumstances in terms of cost, time, instructions, efficiency as well, and should develop a strategic plan to approach to solving the client's problems, which may involve a range of different remedies and which may need to be prioritized in the event that unforeseen circumstances or inadequate or misleading client instructions no longer make the original choices available or viable. Now, students have not done well in this question in the past, and I have in the past allowed for the newness of this approach in the course. But we are now 3 to 4 years inside of this area, and it is not as though students don't know the law that is involved with alternative remedies. Okay? So increasingly, this is going to be marked harder and harder in that I'm going to be much more stringent on the kinds of processes that students use in addressing this particular area of the course. Okay? And we have, and particularly because I've developed new tools that you will look at, especially in solving the client's problems, alternative remedies. And there are 2 important exercises that are designed for you to do, which are compulsory. If you don't do it, well, you do it at your risk. But these are the tools that are designed to help you to channel you into making these kinds of assessments and to making reasonable and reasoned approaches to solving your client's problems. I say no more. Now, presentation. I want to link this to the video on language and the materials on the blog. You will see in learning resources that there are materials dealing with legal English. So let's just go into this. Students must be able to follow instructions. They must be able to answer the questions which are asked. So answering questions which are not asked or answering in a manner which is contrary to your instructions will be penalized. Okay? So follow instructions. Structure and organize your answer using headings and subheadings is strongly recommended. Logically developing ideas, articulate clearly relevant principles of law so as to represent a sequential argument is very important. Take my comments on, there's a separate video on the use of argument, especially, and I compare the Lord Kitchener's Calypso, Love and the Cemetery in terms of structure to the structure in legal argument. I think that's important. You choose for yourself. You'll be tested on your ability to express yourself in standard English, including proper grammar, use of proper form and formatting, use of paragraphs, etc. As I said, this is the video, the materials on on Legal English, which is there on the blog. Use it if you know that you are challenged with English language. And you should have legible handwriting. If your handwriting is very large, skip a line between paragraphs. Writing, if your writing is small, try and write as large as possible if you know that that is a problem. Okay. All right. So there are resources to address many of these issues in this particular criteria, which you will have to deal with on your own if you don't use the material and you can't uh, can't uh, express yourself effectively and express yourself in English language, then of course points are going to be deducted from your presentation. Okay, and where presentation is important, where this is important is where you are weak in other areas, and just a 1 or 2 point difference makes the difference between passing and failing, or between one grade and another grade. Okay, so if you don't think that it is having proper English language skills are important, then if but you are strong in every other area, that is fine. That's a risk you could decide to take. Okay, but if you are weak in the other areas, then and you are also weak in your English language skills, then that is going to make a big difference in your results. Okay, so let's look at how these principles are applied. As you can see, all of the major criteria are listed on this left margin, and you are marked from 1 to 5 in relation to each of them. So that if you got 5 in each of them, then 5 fours are 20. That's a 100% score that you will make. So when we look at the knowledge of substantive law, we ask ourselves in relation to what you have done, whether you demonstrate comprehensive and authoritative knowledge of most relevant principles of law. And I say comprehensive because the knowledge has to be to demonstrate that you know the law and you know most, and that knowledge is a good knowledge. Because it's an examination situation, I don't expect it to be perfect, but it should be comprehensive. And for a 5, it has to be authoritative, meaning that you have to demonstrate your knowledge of the law based on authority, whether the authority is case law or legislation or whatever. So 4 means that you demonstrate a comprehensive knowledge of most principles. 3, you have to demonstrate sufficient knowledge of most principles. 2, limited knowledge, and 1, have limited knowledge. And you can go through these and see that they descend from top to bottom, from left to right, and where you will normally position yourself. So that you don't have to sorry, let me just, okay. So let's talk a little bit about most relevant principles of law. It means that you don't have to know all the relevant principles of law, but you should be able to know most, and the principles must be relevant. Okay, you must be able to apply the circumstance for 5 consistently applies principles of law to the relevant facts presented directly, clearly, or indirectly. For 4, in most circumstances, you apply principles of law to the relevant facts. For 3, you apply principles of law only or mainly in the cases where the relevant facts are obvious. In other words, deliberately, there are going to be facts that, well, everybody knows. But then there are also going to be facts that are put into the question which raises issues of ambivalence, or which may not be as obvious, or they are obvious because you can see them because you know the law related to them. If you and that is what sometimes happens. Okay, And so you go down and you can see how you will apply these rubrics to get a score. And this is how we mark you in exams. Now, overriding all of these things are what I call professional standards, that of a competent attorney using all skill and judgment. Okay, that's what I'm looking for you for. And therefore, sloppiness, lack of research, carelessness, or using information that is available, or not using information that is available, or has been made available to you, will not be tolerated. Okay? We expect you to prepare for and attend and participate in class and on the blog. These are all designed to help you. We expect you to question and be critical, to strive to attain the standard of work that defined above, and also to come to the realization that good enough for me is never good enough. Always strive for excellence, and you may actually achieve good. Honesty and integrity in all things, these are professional standards that, for me, that I am putting forward to you, which I believe will be helpful to you, not only as a practitioner, but will reflect in what you're doing now. And my final thoughts on assessment. I would like you to reflect on the marking criteria as outlined here and determine for yourself whether the use of templates, concept maps, structured argument is useful to achieve the objectives of the assessment. This will help you to understand what we as examiners are looking for in your work and can guide you to improve your performance as students and as attorneys. Let me just go back a little bit. And talking about self-reflection, this should be are useful instead of right. Concept maps are useful to achieve the objectives of assessment. And that shows you that even with me, I constantly have to reflect and review what I'm doing. So I want you to see reflective assessment as a habit that has to be ingrained in you as part of your DNA as a lawyer in order to achieve good standards. And I want to talk a bit about, just quite briefly, about the concept maps and all of the other things, elements that I have tried to expose you to in the series on solving the client's problems. Okay? We've talked about different types of argument. We've used concept maps, we've used templates, we've looked at how we approach the assessment of, how we approach dealing with alternative remedies. We've talked about how we deal with the assessment of damages. There's a critical link between those approaches and the marking criteria. I hope you will be able to see it, that it relies strongly on knowledge of your substantive law. It requires an approach between the law and the facts. It requires solving your client's problems, and it involves especially structure, presentation, logic, and sequence that helps to draw the argument in all its diverse parts into a holistic whole that solves the client's problems and that persuades the judge or the audience that you are presenting to that the argument has been sufficiently made. Okay? So that the marking criteria is an integral part of how you practice as an attorney. And that's one part. And then it also helps you to reflect. It gives you a basic discipline from which you can determine how effective you are. So most importantly, the practice of self-reflection, I believe, is the most important tool of the lawyer to achieve and maintain excellence. At the end of the day, no one will be with you in practice to guide you as to how to do your research, how to develop your arguments, and how to present them. It is you who will have to set the standards for professionalism and find the means to be true to it in spite of all the distractions. Being eternally reflective of your work in reference to your standard is the only way to do so. If nothing else, I hope this process will give you this lifelong ability to sustain excellence in all you do. Thank you very much.